the meetings to then go ahead and make a decision. The submission we make in that regard is, apart from not constituting an adequate substitute for analysing and giving proper consideration to Heritage Western Cape's letters, the letter is inherently illogical. If the Minister was indeed satisfied that the developer's document satisfied Heritage Western Cape's requirements in terms of 38.3, there was no need to send a letter in the first place. The very fact that the letter is sent constitutes an acknowledgement by the Minister that the requirements had not been satisfied. Given that Heritage Western Cape's letters of 13 and 13 February are clear and have been supplemented by...
But my impression is that the Minister needed assistance.
I beg your pardon, the Minister?
My impression is that the Minister needed assistance from HWC. I'm looking at paragraph, the 5th point here. Did the HWC assist the Minister by providing additional information as requested? Or did the HWC just ignore this request? I'm on page 16.
Yes, I'm with you. I'm just checking my notes to see what the position was after that. My understanding, if I remember correctly, and I speak subject to correction, is that they reiterated the position in their earlier letters. But it's not an unreasonable stance, bearing in mind they've already had the meeting that I referred your ladyship to and referred to in their earlier letter, in which they sat with the heritage consultants. They listened to the heritage consultants, heard their representations, and that was their opportunity to obtain clarification. So they've sent 2 letters, they've held a meeting with the heritage consultants. What more are they expected to do? And the director knows, he tells us in his affidavit, he knows the main thing that's missing, which is the report from the specialist consultant. He must have told the Minister that. The Minister must have been aware of that. So, lady, we then submit that in any event, it's now paragraph 156, the compliance of the heritage impact assessment with the requirements of Heritage Western Cape is a matter which is objectively justiciable on review by this court, and the foregoing analysis demonstrates that the Minister was wrong.
Wasn't it a missed opportunity for the HWC? If you have information, you must provide it. If assistance are requested, you must assist. You appear to be a competent authority, if I can use the term. If the Minister needs additional assistance, should it not have been provided? And contextualized and clarified.
Lady.
But the HWC, can I use the term, actually withdrew from the process? Is it correct to say that the HWC then withdrew from the process after the Minister requested clarification and information?
I will check whether there was further correspondence subsequent to this.
But would that be the correct approach when a Minister communicates with you, asks for information, and you just fail to provide it?
But possibly, my lady, what one must also bear in mind is the sections of the replying affidavit that I read to you. They set out their position. They get a series of belligerent letters back from the heritage consultants, who are driving up the tension by the language that they're using as well in those letters.
Yeah, but that won't assist the Minister in any way, any personal issues that may surface in this matter.
Well,
that's irrelevant.
Well, except that...
The fact is, you hold this current position in terms of decision-making, commenting on, giving guidance on the issue of heritage. The Minister requires information, and you just decide, look, we're not going to engage further.
But, lady, if it was a genuine quest to get more information, why does the letter not cover several pages and say, I understand this paragraph. I don't understand this paragraph. Please, can you help me here? I do understand this paragraph here where you're saying that there had to be meaningful consultation. I do understand this paragraph where you say there had to be the appointment of a specialist consultant. That isn't what's happening here.
But could the HWC not appoint a specialist consultant? And I am really just throwing it out there. I'm trying to establish how should they have dealt with the minister's request. Should the HWC not have responded to the supplementary report to the HIA by presenting their own expert report? I'm just asking, was that an impossible solution to this problem? Or was the HWC just merely avoiding its mandate by not responding and not assisting the minister? By responding to the issues raised, more particularly the supplementary report as well as the heritage impact report, which according to HWC does not satisfy the requirements of Section 38(8). How can it assist the process if HWC decides we're not participating further and they are not here today? They're not a party to these proceedings. How can you resolve this problem?
My answer to your question is perhaps they should have attended. We don't know what the dynamics were.
No, I think there was a duty on them to assist the minister, because you cannot throw something out there and say, and I'm actually back to to an issue that we raised earlier on with regard to a party who does not participate. But here the minister needed assistance. Now, HWC was given an opportunity to assist the minister. They could assist, they had a discretion how they would like to assist the minister, whether they obtained their own expert report that is being criticized today in court. It's alleged that we don't have this expert report that can really comply with the provisions of 38(8). Why did HWC not obtain such a report and write to the minister and say, look, in the circumstances, we are of the view that a meeting will not be beneficial to the parties. We will obtain a specialist report to assist the minister in contextualizing the requirements that have not been met and how it should be addressed by the minister.
Lady, if one looks at the way that the environmental impact assessment regulations work, it's the developer that gets the experts. It specifically provides for specialists. They're working in tandem with what the legislation says.
I understand that, but I must engage you on the attitude adopted by HWC, because the applicant is here today raising the issues raised by HWC. The HWC responded, they participated. So it's not as if they ignored the whole process. They participated up to a certain point where the minister then requested clarification, and they were not there to clarify issues, which resulted in the decision that was made. Because in paragraph 5, the minister says that I will surmise that the supplementary report to the heritage impact report does satisfy the NHRA, and that HWC's requirements in that all issues raised have then been adequately addressed. And I think that was the basis on which the minister made a decision in this matter.
Lady, perhaps they should have. Perhaps it would have been wiser for them to answer the letter. But I think one must understand the dynamics, and they're set out in the replying affidavit. I won't go there again. But the crucial part is there are substantial parts of that letter which are perfectly clear, which the director already understands. That's why he sent the letter of the 17th of February. So there are certainly, on any test, aspects of it that are clear and that have to be complied with. And if they fail on the aspects that are clear and have to be complied with, none of this really makes any difference at the end of the day.
So are you saying the onus is on the developer to obtain a specialist report? the applicant alluded to the fact that because the developer appoints, the expert compiles a report in favor of the developer. I think that the applicant alluded to the point that since the developer appoints the expert tends to comply with what the needs of the developer. That's what I saw in the papers. Was HWC barred from obtaining a specialist report to deal with the requirements of 38 and provide it to the minister in support of the views that they hold? Were they barred from doing that? Was it primarily the responsibility of the developer?
Indeed.
Could the HWC not assist the minister by obtaining a specialist report since they criticized the supplementary report? And I am just trying to establish whether there was any reason why HWC could not do that.
Well, I think I can state with a reasonable measure of confidence that there wouldn't be a budgetary allocation to Heritage Western Cape to assist a developer with satisfying the requirements of the legislation. And if you look at Section 38.3, the way it's structured is that they tell them to supply the information. That's exactly how Section 38.3 works.
But it's not the developer that needed assistance. It's the minister before they make their decision. It is not the developer that required or asked for assistance. It was the decision maker that required assistance. So it is not expected from HWC to assist a developer to get approval for their project. That is not the issue. That is not the issue that we're debating currently.
The minister wasn't asking for help for himself. He was saying, he was purporting to say contradictory things. He was saying, on the one hand, he's satisfied now that on the basis of the 31st of March letter, they've complied.
Because there was nothing forthcoming from HWC, and the court can not even interrogate that here today because they are not here. And the applicant appears to rely, applicants appear to rely on the case or the objections raised by HWC. I'm not satisfied with the response. I'm trying to ascertain from the applicants. I'm engaging on the statement made that it's not for HWC to assist the developer, but that was not what is at issue here. The decision maker needed assistance, and HWC did not assist.
Lady, what the statute envisages, if we have a look at 38.3.
Or did HWC not have a duty to assist the minister and provide certain information as requested by the minister, failing which the minister was going to make his own conclusions? That's what the minister stated,
well,
or alluded to.
It's not part of the structure. Mm-hmm. And what the minister was saying is, clarify your requirements to the Heritage Impact Assessment Specialist, not to me. I don't read this letter as him seeking assistance from Heritage Western Cape.
I think that is a big problem in this matter. There's some lacuna here created by HWC who did not respond to the decision maker. Now the parties are presently here at court, but not the HWC to explain what their position is, because the court would have engaged HWC and asked them, why did you not provide the information? In other words, why did you not contextualize what was required to be done, which was not done by the respondents and the decision makers?
Unfortunately, we don't have them here, my lady. But yeah. let's assume that it was wrong of them not not to have responded doesn't detract from the fact, doesn't take away from the fact that the process that took place was invalid. And it was invalid for several reasons. It was invalid because of the post-rationalization of preconceived development, which is absolutely clear on the respondent's own version. It was invalid because they didn't do the mapping properly. It was a clear requirement. It was invalid because they didn't do the consultation properly. I know we've had a debate about that. We submit that it wasn't a proper consultation. It was invalid because they didn't provide a specialist report. So let's assume Heritage Western Cape are to be criticized for not having provided a further letter. Doesn't take away from the fact that the process was invalid.
But one specialist report could have dealt with all the issues that you just mentioned now.
Well, then why didn't they do it? Why didn't they do it? They stubbornly refused to do it. Why should Heritage Western Cape step in to the breach when it's the responsibility, in terms of the statute, of the developer to provide it? Section 38.3 specifically says, Heritage Western Cape says to the developer, you do this. They say to the developer, go and appoint a specialist consultant. They don't do it. The consequence of that automatically...
Well, they filed a supplementary report, which they perceived to be adequate, which the applicants do not perceive that to be adequate. But everything is based on the recommendations of HWC with regard to requirements in terms of Section 38.8. So, is the fact that HWC never responded and contextualized what was exactly required, what should the respondents have done that they did not do, is that not a problem in this case? That HWC practically withdrew from the process, which resulted in the decision maker accepting that was presented by the developer. And the point I am making, if I can rephrase my statement, is the applicant comes to court, the applicants come to court on the back of HWC's comments, statements, views. But there's a lacuna somewhere in the conduct of HWC, because they elected to stop engagement at a certain crucial point where the minister called for assistance, guidance, information, which was never contextualized, which resulted in the decision that is being contested.
Even if I assume that they were wrong in not meeting, there isn't a causal link between that and the flaws in the heritage impact assessment process that I've outlined.
But it's easy
and
to say
summarized.
There was non-compliance with this section and that section without contextualizing it. Anyone can do that. And I went through the record and I saw this golden thread running through this record. I actually made a note somewhere. I just couldn't find my note earlier this morning, so I gave up. But what exactly should have been done with regard to tangible heritage resources, intangible heritage resources? What should have been done that was not done to satisfy HWC that there was compliance? And I did not find the answer in the record, and I must pose that question to the applicant. I didn't find it in the record.
Bear with me for a moment.
From my understanding, the minister also requested additional information. You cannot say there is non-compliance and you don't specify, and the court would like to hear the applicant's submission on the following proposition. If HWC can make a decision not to engage the minister. And that then creates a vacuum somewhere, and that contributes to an attack on the decision made by the decision maker. But would that be a fair attack if you rely on the grounds raised by HWC? But HWC never assisted the minister when the minister called for assistance. Paragraph 4 here reads, should you wish to clarify and provide additional information on the HIA requirements to supplement the current HIA and the supplementary report. That is the assistance that the decision maker required, and it was not provided to the decision maker. The approach adopted by HWC resulted in this matter coming so far, where the parties actually are here, all here today, without any explanation of what the HWC actually meant. Do we know exactly what HWC meant?
But
Why did they not respond to paragraph 4 and 5? Or must we speculate? They did not file anything? They did not assist the minister?
But your ladyship says there was no assistance provided. There were two letters. There's the 13th of September letter, 2020. There's the 13th of February 2020 letter. There's the meeting that took place before the 13th of February 2020. There's the appeal. There's the submissions they made when they submitted the appeal against the director's decision, in which they set out their position. This wasn't a recalcitrant statutory body. And the minister here gives them a choice. He says, I'm going to make my decision. Either you must tell me some more, or I'm going to make my decision. They're entitled to adopt the attitude. It's not a plea for assistance. He says how he's going to proceed. They're entitled to adopt the attitude that says, we've done everything we can. We've told the developer over and over again what he has to do.
But it's not about what they told the developer. It's got nothing to do with the developer. Absolutely nothing to do with the developer. It's empowering the minister to arrive at a rational decision.
But it inevitably links in with the developer, because the implication is, if the minister says, decides that there is now a requirement that's been clarified, that's simply going to be transmitted to the developer. So that's how the statute works.
Yes.
First, the director, on appeal, the minister, must ensure that the developer provides the information.
But the developer provided the information.
Well,
that is the point that I'm making.
But
then the minister had the information before him, but before he made his decision, he asked HWC for assistance. So I'm not following your argument. Can you just clarify?
My argument, lady, is that this letter effectively gave Heritage Western Cape a choice. It said, provide further clarity, or I'm going to decide the matter on the basis that this...
But there's nothing wrong with that approach. I think the letter was actually quite transparent.
That's not...
And it was actually stating the minister's position that based on what I have now,
but with respect, lady,
this is how I consider it. Just pause one moment. I'm interjecting because I don't want your starting point to be incorrect. As a starting point, the minister communicated openly, and he was transparent. Or was it she? I think it's him. In any event. So, would it be fair to say that paragraph 4 and 5 is some sort of foregone conclusion?
So
by the minister to actually approve? It cannot be, because the minister acknowledged in paragraph 4 and 5 that I need additional information.
Well,
because based on what I currently have, it appears to me there are no problems. That's what the minister says.
So he says, if we can just read them, I've reviewed your comments dated the 13th of February 2020 and the 11th of December 2020, as well as the information provided in the supplementary report to the HIA report dated 4th December 2019 as well as the applicant's responding statement dated 12 December 2020. Again, confirming all of the responses that Heritage Western Cape have indeed given. I'm of the view that the issues you raised in your response dated 11 December 2020 have been addressed in the applicant's supplementary report to the HIA report, as well as the responding statement. Should you wish to clarify and provide additional information in the HIA requirements to supplement the current HIA and supplementary report, please submit this to the Ministry of Local Government. Should you not provide me with an indication of such information, I will then surmise that the supplementary report to the HIA report does satisfy the NHRA, HWC requirements, and that all issues raised by yourself have been adequately addressed. He says what's going to happen if they don't respond, and they don't, and they don't respond. It's a prediction to them as to the way forward that he's going to follow. They're entitled to say at the end of the day, there's nothing more that we've got to say, and we aren't going to respond. But if we, upon an examination of the process and the exchange of documentation that took place, can demonstrate to your ladyship from the documentary record that in fact there are requirements in terms of section 38.3 that were not satisfied, the applicant can't be precluded or denied their case based on the fact that Heritage Western Cape chose to go with the option that said we're not going to respond further. Applicants didn't do anything wrong in these circumstances.
But the applicants are relying on the grounds raised by the HWC.
It may be that if...
They're practically stepping into the shoes of HWC, isn't that so?
With respect, no, my lady. They're an impacted party exercising their constitutional rights who stands outside of this process.
Yes, but the grounds raised,
it
corresponds to, it aligns with the views adopted by HWC. Is that not so? There's not really anything new that the applicant raised that wasn't raised by HWC, isn't that so? Because the applicant is using this letter now, today, to argue that the very fact that the letter is sent constitutes an acknowledgement by the minister that the requirements had not been satisfied. The HWC didn't assist the minister. The minister made it clear, unless you provide me with further information, this is the conclusions I'm going to arrive at. That is clear, open communication of the minister to say, from what I have in front of me, I'm quite satisfied that there was compliance, but please provide me with information so that I can make a decision whether I missed something or misunderstood something.
Page 303 is the response from Heritage Western Cape. It says your letter dated 26 January in the above refers. Heritage Western Cape cannot agree with your contentions.
What is the date of that letter?
This is dated the 3rd of February 2021.
3 Feb.
Heritage Western Cape cannot agree with your...
Did you say 13 Feb or 3 Feb?
3.
3 Feb, right?
Page 303. Actually,
that's prior to the letters, the minister's letter.
A reply to the minister's letter. So it's not as though they simply ignored the letter and did nothing. They responded and set out their opinion. And their opinion was as follows. Your letter dated 26 January...
Can you just pause for a moment? In terms of the chronology, the letter you are referring to now, was it sent before the minister requested additional information or after the minister requested assistance?
As I understand it, in response to the minister's request for additional
information. As a response? We know that WC said, look, we're not taking this matter further. In your view, it looks like we won't be able to persuade you. You're firm in the views that you hold. That's why we're not engaging you further. We know that is the view of HWC. I just need to contextualize their response vis-a-vis the minister's letter.
Certainly,
that is
all.
They made a decision they're not going to engage the minister further after his letter.
We'll work out what that's what that's responding to.
Insofar as the second part of the proviso to section 38.8 is concerned, the minister's decision, despite its considerable length, is devoid of any attempt seriously to take into account the comments and recommendations of HWC. But the HWC missed an opportunity to actually respond to the minister when the minister called on them to assist further and provide information. The words that were used was clarify and provide additional information.
So the response was as follows. Your letter dated 26 January in the above refers. Heritage Western Cape cannot agree with your contentions as stated in paragraph 3 thereof. It is reiterated that Heritage Western Cape is of the strong opinion that the supplementary report to the HIA report dated 4 December 2019 and the responding statement dated 12 October 2020 merely restate the initial opinions expressed in the original HIA and do not in fact address the issues that HWC raised in its final comment. We can accordingly not also agree with the sentiments expressed in paragraph 5 thereof. So whether one agrees or disagrees with them, it's a legitimate viewpoint that they've adopted. They say, we think that we are clear enough. We think we've said what had to be done. They interpret their letters being clear.
The supplementary, I'm just going through my own notes, but I know I made a note here that the supplementary HIA, the HIA and the supplementary HIA, what HWC said was, you're just rehashing what was already said. That is the point you made now.